Yes, I'm Jay Wilkinson, and I've been a judge on the Federal Court of Appeals for the Fourth Circuit since 1984. President Reagan appointed me, and I think more importantly, I'm a father of two children, and just had my first grandchild not so long ago. Well, I think the purpose is in significant part an educational one, not just for the bar and the rest of the bench, but for everybody. And the Chief Justice is wonderful in communicating the aims of the judicial system in a very straightforward way and in a very humorous way. And when he talks, I think it makes people respect the judicial system all the more. And what I'm trying to do with an interview is give the subject of the interview a chance to get across the educational points about the judicial system. You know, we're the most obscure of the major branches of government in one sense. Our deliberations are behind closed doors. We're deliberating on a case, and nobody knows the course of those deliberations, or they shouldn't, until the case comes down. So there's a bit of this mystique, you know, the judges or the justices hear oral argument, and then what happens? They disappear behind this red curtain. Nothing ever to emerge until the decision comes down. So you have this basic obscurity and what is necessarily a certain lack of transparency to the way courts decide their decisions. They may add to a certain mystique, I don't know, but we need to understand that people don't know about the judicial branch because we don't have to face them in elections. We don't go out and just glad hand and, you know, socialize the way their elected representatives and others would. Okay, so given that, don't we have a major educational mission to perform to at least try to inform the public of how, in a general manner, we go about deciding cases, and at least to talk to them about the values that those of us in the judiciary hold dear, how we conceive of our mission, why it's so important to have a system of independent courts, and, you know, occasionally to have the interviewee, you know, drop a little personal tidbit or something which is of interest, because you want to humanize the process too. So it makes sense to ask, what's your favorite movie? Or what's your favorite book? Or, you know, what did you think of somebody that you clerked for? You know, we're not, you know, we're very human, which means we make mistakes, but really try to get the interview, you know, to appreciate the humanity, and the Chief Justice is wonderful at that. And I say this, he's a great representative of the federal judiciary. And when you talk to him, you realize how seriously he takes the values that the third branch represents. Yeah, I mean, I think the answer to a question like that is very circumspect, because you don't want an answer to be construed as throwing off on any particular individual or the composition of any particular court. So, you know, these judges really have to be careful about what they're saying, and particularly when you get to the level of Chief Justice Roberts. But the interesting development is that in the days of the 1950s and 60s, you had a number of justices who were former United States senators. Some of them had been former attorney generals. Some of them had been governors. Some of them had spent their lives substantially in private practice. And so the development was that overwhelmingly now, the justices have come from the courts of appeals. The reasons for it, I suspect, so there is this trend, and it's just impossible to deny it. The reasons for it, I suspect, are that you want that judicial experience. I think that's one reason. Another reason is, to be perfectly blunt, the appointing authority, maybe the issues before the courts are so controversial that the appointing authority wants some clue or indication as to what the prospective nominees' views are. I mean, it's inescapably, the confirmation process is a political one. So the question is it a good development? And that's not an easy question to answer, because I do think that judges who've been on the Court of Appeals have brought a set of judicial skills and know-how and expertise in terms of the law, and they bring a very large and general legal background, which allows them to hit the Supreme Court running. But the other side of it is that there's a large slice. In fact, the vast majority of American life is really taking place outside the courthouse walls, and you might want people to have really kind of bloodied their nose in politics before going on the bench. I happen to think that politics, you have to put it aside when you go on the bench, but it teaches you certain things. It teaches you the values of compromise. It can teach you the importance of keeping commitments. It teaches you about people in all walks of life and what matters to them and what they're saying and what they're thinking. And so, you might want people who are a little bit beat up, and I say that in the best kind of word, by the political fray. And it's also important that courts respect the legislative process and the political process, and show restraint in the face of legislative judgments. And it might help if you'd actually been in that process and saw the way the sausage was made. Well, that's a good question, and I think just as a citizen, we all wish that there was less gridlock and more compromise, and that's there's a natural desire for that. So but I don't think that the fact that there is gridlock and that there's too much gridlock, which I think we would all agree on, that's no reason to give up on the legislative process. I mean, people come to me and say, "Oh, I just despair of Congress," and I can understand that, but politics by its nature is messy. It's not a lovely enterprise. It's not clean. It's it's rough and tumble stuff. And given the way this republic of ours was designed, with two houses of Congress and the states and the federal government and the executive and the courts, and you've got separation of powers and all these different centers of power, this Madisonian system is going to produce endless contention. That's the way it was designed. Would James Madison have just, if he were somehow brought back to life, would he be wringing his hands and just deploring the modern day Congress? And I'm not sure he would, because they had some pretty rough battles back then. When you think of what was going on in the election of 1800 and what Thomas Jefferson and John Adams were calling each other, with a little bit of some of this stuff is child's play. And so I don't think he was not a naive man. He was an intellectual, James Madison was, but he was right there in the middle of the fray. And he knew what was going on. So the system is going to produce a certain bit of gridlock. Was gridlock the worst sin that the framers of our Constitution could imagine? No. There was a greater danger to be avoided, and that was the danger of tyranny. And as between gridlock and tyranny, I don't want to oversimplify the question, but I think Madison's factional design would have preferred the argumentation and contentiousness of gridlock, because nothing was worse than losing this marvelous American experience of self-governance. Nothing would be worse than to have judges attempt to become super legislators in their own right. Nothing would be worse than to have an all-powerful executive. Nothing would be worse than to have a Congress completely unchecked. So you're going to have a certain amount of gridlock. But my gosh, how much better is that than tyranny when you get right down to it?